applicant had brought an application before this court for the following orders. 1. Directing that an investigation be held into the delay in the completion of the proceedings in the case in terms of section 242, capital A, paragraph 1 of the Criminal Procedure Act 51 of 1977. 2. Granting the applicant bail in the case in an amount and on such conditions as the above honorable court may deem appropriate. 3. Granting the applicant further and stroke or alternative relief. The respondent had opposed the application. After considering the evidence presented by both parties, both written and oral, this court, in a judgment that was delivered on 4 November 2020, dismissed the application for the reasons fully set out in the judgment. The present application is for leave to appeal against such judgment. The grounds upon which the application for leave to appeal is premised are set out in the applicant's notice of application for leave to appeal, which was filed off record on 9 November 2020. The grounds of appeal set out in the notice span some 10 pages and are largely repetitive. To cite a few examples of such application. A. In paragraph 13, the stated ground is that the court misdirected itself in holding itself bound to the findings of Hossein J. in the said appeal. In paragraph 22, the ground stated is that the court misdirected itself in deciding the application on the basis that it is bound by the finding of the magistrate and Hossein J. Once again, the ground stated in paragraph 23 is that the court misdirected itself in deciding the application on the basis that the magistrate and Hossein J's findings are correct. B. Ground 31 states that the court misdirected itself in failing to bring a balanced judgment to bear on the proved facts, while ground 33 is that the court misdirected itself in delivering a one-sided judgment. C. Ground 48 is that the court erred in failing to find that the respondent sought to put up a spurious case in opposition to the applicant's application for bail. Ground 49 is that the court erred in failing to find that the respondent, in effect, would have no case in opposition to the applicant's application. Ground 50 is that the court erred in not attaching any weight to the respondent's attempt to put up a spurious case in opposition to the applicant's application for bail and its failure ultimately to put up any case whatsoever. Ground 57 is that the court erred in failing to determine that there has been an unreasonable delay in the completion of the proceedings. Ground 62 is that the court erred in failing to conclude that there has been unreasonable delay in the completion of these proceedings. At the commencement of the proceedings, the court engaged Mr. Price SC, who appeared for the applicant, with regard to the relief sought in prayer 1. Expressing its prima facie view that such relief can only be properly sought before the trial court, which is seized with the main trial and not this court. Since section 342, capital A, in brackets 1, refers to the court before which criminal proceedings are pending as the one that should investigate delays in the completion of the proceedings which appear to the court to be unreasonable and which could cause prejudice to one of the parties. Mr. Price requested to address the issue more fully after all the evidence had been laid, including oral evidence. After the evidence had been laid, and at the commencement of the final address, the court reminded Mr. Price of his earlier undertaking to argue the aspect of the court's jurisdiction to deal with prior 1, and that he would further address that aspect after all the evidence had been laid. Mr. Price considered that he had made such undertaking When the court pointed out to Mr. Price that no evidence had been laid with regard to prayer 1 and inquired whether he was still pursuing prayer 1, his response was that he acts on instructions, but he would not argue the prayer any further. He invited the court to draw its own conclusions, which he would not regard as unfair, from the lack of further argument with regard to that prayer. The clear effect of Mr. Price's address on this aspect was that the relief sought in prayer 1, even though not formally abandoned or withdrawn, was no longer being pursued, and that the court should concentrate on prayer 2, the renewed bail application on new facts, in respect of which evidence had been laid and the final address concentrated on. The respondent's counsel, Mr. Mtoromba, has argued that on those facts, no argument at all was directed at dealing with prayer 1 in the final arguments, as the respondent had understood that prayer as having been effectively abandoned on the basis of what is stated above. That being the case, the grounds of appeal that criticized the manner in which the court has dealt with prayer 1 would appear to be opportunistic. Since prayer 1 had not been formally withdrawn, the court saw the need to first deal with it in its judgment in paragraphs 1 to 10 thereof. I am of the view that there are no reasonable prospects of another court coming to a different conclusion with regard to that prayer to the one that this court arrived at. Accordingly, there are no reasonable prospects of success on appeal with regard to that. That takes care of grounds set out in paragraphs 1 to 7 of the applicant's stated grounds of appeal. As his 8th ground of appeal, the applicant contends that the court committed a gross irregularity by allowing the respondent to call Kenan Magwandana, who had previously testified for the applicant on a totally different aspect, as a witness for the respondent on another aspect. During argument, when the court requested Mr. Oberman to refer it to any legal authority, be it a legal textbook or case law, in support of a gross irregularity contended for by the applicant, he was unable to do so. He contented himself with the submission that such procedure is obviously incorrect and unheard of, hence there are no legal texts that deal with it. I can find no merit to this argument. I am of the view that there are no prospects of any other court considering that procedure is an irregularity, least of all one that should vitiate this court's decision on the reliefs sought in the application. Grounds 9 and 10 criticize the court's finding that the evidence led by the respondent with regard to the threats that have occurred to the state witnesses, both before and after the last bail application, shows a likelihood of the state witnesses fearing to testify against the applicant in the event of the applicant being granted bail. There is no merit to this criticism. Reasons for that finding are fully set out in the judgment. Grounds 11 to 13 condemn for a misdirection by this court in referring to and relying on the findings made by Hussein J. in the applicant's appeal against the magistrate's refusal of bail, and that the court misdirected itself in holding itself bound to the findings of Hussein J. in his appeal judgment. There is no merit to these grounds. Nowhere in the judgment is there any indication, either expressed or implied, that this court held itself bound to the findings of Hussein J. This is bail that is brought before this court, bail application that is brought before this court on new facts, which were not in existence at the time that Hussein J. made his findings. The court was bound in that application to consider both old and new facts. It would make no sense for the court to hold itself bound by Hussein J.'s findings. Hence, it never did. There is no basis whatsoever for the applicant's contention. The grounds in paragraphs 14 to 16 of the Notice of Appeal condemned that this court committed gross irregularity by disregarding and not considering portions of the evidence that was presented before it, and ruling that some of the evidence does not constitute new facts and will not be considered. Once again, there is no merit to this conviction. At the bottom of paragraph 12 of the judgment, this court has made it clear that in dealing with a renewed bail application on new facts, the court would consider all the facts before it, both new and old, and on a totality come to a conclusion. Similarly, in paragraphs 16 and 17 of the judgment, this court clearly indicated that it would consider the effect of the new facts in conjunction with the evidence led in the present and previous bail applications, taking into account all the documentary and oral evidence presented in both applications in its determination as to whether the requisite exceptional circumstances that, in the interest of justice, entitle the applicant to granted bail have been established by the applicant. In those circumstances, the stated grounds in support of the application for leave to appeal are totally devoid of basis or merit. The contention in grounds 17 to 19 that the court failed to properly consider, analyze, and evaluate the evidence before it, or to assess the credibility of the various witnesses, is equally lacking in basis. As already indicated, and as the judgment itself clearly indicates, all the evidence that was presented before the court was fully and properly considered, analyzed, and evaluated by the court before it came to its conclusion that the applicant had failed to discharge the onus that rests on him in terms of the provisions of section 60, in brackets 11, in brackets 8 of the Criminal Procedure Act. The grounds on paragraph 20 and 21 that relate to the court's alleged failure to make specific findings of fact on the evidence are equally lacking in merit. The manner in which this court analyzes, evaluates, or assesses the evidence before it is for the court to decide. It is not open to the applicant to dictate to the court how it should do such evaluation or analysis. Regarding the grounds cited in paragraph 22 to 26, I reiterate that nowhere in the judgment is there even the remotest suggestion that this court decided the application on the basis that it is bound by the findings of the magistrate and Hussein J, or that it decided the application on that basis. Neither is there any suggestion in the judgment that the court placed an onus on the applicant to show that the magistrate and Hussein J's findings are wrong. The criticism that the court did not consider all the facts or failed to bring an unfettered judgment to bear on the issues has absolutely no basis or merit. Grounds 27 to 30 condemned that the court failed to consider or apply the appropriate standard of proof, which is on a balance of probabilities in deciding the application. There is no basis for this submission. Throughout the judgment, the court has repeatedly referred to the applicant having an obligation to discharge the onus that rests on him in terms of the provisions of section 60, in brackets 11, in brackets 8. Even the most cursory reading of that section shows that the onus referred to therein is that of proof on a balance of probabilities. That is the onus that this court expects in his application. Grounds 31 to 33 condemn that the court failed to bring a balanced judgment to bear on the facts, and that it delivered a one-sided judgment which only took into account factors that militate against the granting of bail. Once again, these contentions are without merit. As already indicated, before coming to its decision, the court took into account all the evidence that was brought before it. The judgment clearly indicates that. Similarly, the unsubstantiated and baseless contention that the court failed to give the applicant a fair hearing is equally lacking in basis. Grounds 35 to 42 criticize the manner in which the court dealt with the applicant's prohibited immigrant/person status in terms of Section 29 in Paragraph 2 of the Immigration Act, number 13 of 2002. The criticism that the court referred to the applicant as a prohibited immigrant rather than a prohibited person constitutes nothing else but nitpicking, which is clearly indicative of the applicant scraping the barrel to find fault with the judgment. The meaning and the effect of those terms are exactly the same. The contention that the court refused the applicant bail purely and singularly on the basis of his prohibited immigrant/person status has no basis. As the judgment clearly indicates, this was but one of the relevant factors that was taken into account in dealing with the risk of the applicant decamping and not standing trial. The court was obliged to take that fact into account, not singularly, but in conglomeration with other relevant factors before it arrived at its decision. I am of the opinion that no other court can find fault with the manner in which this court has dealt with that aspect. Similarly, the contention that the court failed to take into account in applicant's favor of the extradition treaty that exists between this country and Nigeria is without basis. The court has fully dealt with that aspect in paragraph 23 of its judgment with reference to relevant case law. The contention in grounds 44 to 50 that the court failed to properly evaluate the evidence adduced by each of the parties in a proper manner has no basis. All the evidence was minutely considered and evaluated by the court before arriving at its conclusion. There is no basis for a contrary contention. The issues raised in paragraph 51 to 33 of the application for leave to appeal have been fully dealt with by the court in its judgment, and there is no need to repeat same. There is no justifiable criticism to the manner of the court's dealing with those aspects, or a reasonable prospect of another court deciding otherwise. Grounds 54 to 63 have already been dealt with above, and they are fully dealt with in the judgment. There is no need to repeat the court's findings thereon. Suffice it to state that, in my view, there are no reasonable prospects of another court finding otherwise. Grounds 64 to 71 are also fully dealt with in the judgment, and there are no reasonable prospects of any other court faulting the manner in which this court has dealt with those aspects before arriving at its conclusion. In the premises, I am of the opinion that there are no reasonable prospects of success in the intended appeal. Hence, there is no basis for granting the leave to appeal that is sought in this application. In the result, the application fails on the basis that, one, it would have no reasonable prospects of success, and two, there is no other compelling reason why the appeal should be held.
As a conclusion, Apparat.
Public. Ja, weet je, dat kind gezag hier, dat is wat wordt vanaf het einde, wat is niemand merkt het. Hier zit je niet, wat? Ja, is het niet. There's a reading that allows you to record or broadcast judgments now.
So,
I don't think that there's been a reading that you guys are broadcast their readings.
okay, so meaning I have to be written now.
Yeah.
Okay, so. Thanks.
Oh, same time. Yeah, fine. We want the drive. You want to come here? Is it fine? No. Okay. But let me wait for the other. Let me wait for the other.
Hi Veronica. Okay, so it looks like I need to be written now. No, I didn't say that. There have to be two other rulings before that, and then the main case starts. But apparently there's a ruling that I can't stay, so I need to move now. Okay, say bye.
We're having a big house, isn't it? And we don't it's not a small thing, but half the big house. Yeah. The pothole.
Can you?
I know.
Concentrating too much on the camera, but
Yeah, I'm
yeah, well, I'll just walk into Devon and he says there's two shots. One of the is delayed and then the main off starts again. So, yeah, as far as I understand, yeah. But I don't have rights to stay apparently. He said there's a ruling that I can't stay with the camera in here. Yeah. So I'm going down now. Yeah, okay. Okay, I'll phone her already, alright. Okay, bye.